not following traffic signs. I had a client before where a traffic officer was following him because he was in the fast lane of the motorway when all the other lanes were clear.
Right.
And the officer was flashing him. He didn't move over in time. So when they stopped him in the end, they done him for careless driving. Because
So is that so? Driving in the fast lane of the motorway when the other lanes are clear, that's not an offence in and of itself. Would that be an offence of driving without due care and attention?
if the officer, it's up to the prosecution, the police to prove it was, but if they're writing a statement basically saying we've warned him, the laws of the road, the highway code says this, and he's not doing it. I mean, the officer didn't seem like he was going to write him up and pull him over for that. He gave him at least 4 attempts to pull over, but after 4 attempts, it was not only the driving without due care and attention but not going over to the lanes, it was also him ignoring the flashing from the officer. Obviously, he wasn't looking in his mirrors as well.
So there's more to it.
There's more to it. There's always more to it.
And someone that commits that sort of offence, what's the penalties?
So it's fines and points, and it's case by case dependent at all time, depending on how far we can mitigate it. There are defences to this. It's not a...
Yeah. What are the defences?
The defences are similar for every traffic offence, but for this one particularly, it's necessity. If there was an animal that just quickly jumped out on the road, I mean, we live in England, there's lots of wildlife that jump onto the road all the time. If there was, God forbid, someone that's collapsed in the road, you might have to swerve out the way. If there was a piece of glass that could have burst your tyre, you might have to swerve. I mean, because if you don't, you're going to go over it, your car will flip, and then it'll be even worse for the people behind you.
So circumstances play a big part.
Circumstances, and that's breaks into necessity / medical reasons, because you might have a heart attack, let's say, or you might have a what's it called, a seizure, and you might need to move over, and you might cut a lane or go through a light or something, and that's what's caused. But that's always backed up with medical evidence and backed up with lawyers looking at it and putting it into a way where we can go to court and say, Your Worships, because it will be in the magistrate's court, Your Worships, this is the case, this is the reasons.
Okay, and so driving without due care and attention, dangerous driving, are they separate offences?
Completely separate offences, Paul.
Okay, how is dangerous driving any different to driving without due care and attention?
Dangerous driving is when the drivers, again, legal jargon coming along for our viewers, it's when the driver's driving falls far beyond the reasonable, competent driver and causes danger, basically.
So is it like a scale?
It's a scale, but it's up for them, the prosecution, to prove it. So if you're charged with that, you come to us, and we feel that it isn't dangerous driving and it's more driving without due care and attention or careless driving, we can present that as well because it's more serious. Dangerous driving can carry prison sentences.
And if as solicitors you prove that it's not dangerous, it's actually a lower offence of driving without due care and attention.
Yes.
Does your client does the case close, or do they reissue prosecutions with a different offence? What do they do?
So they could do that, but they also could just change it in court. It's very fast-paced in court. If they want to slow down, we mitigate. We also write representations to for our clients to the prosecution as well. So if I have a look at it and we're given the evidence before the case goes to court, if I look at it and he's just swerved the lane, there's no one around, middle of the night, I don't think it's dangerous driving. It's careless. So we will write representations to the prosecution or the police and say, we believe that this is not what it is. We can tackle it and maybe try and get it thrown out first of all. But if you aim for the stars and just fall on the clouds, you're still doing well. So we'll write to get it thrown out. If they come back and say, well, it's careless, you just saved your clients a potential prison sentence or higher points.
So they downgrade the offence.
Yes.
You can't get off on a technicality that they brought the wrong offence then.
Well, there might be an element, but again, it's case by case dependent. It goes in with how they've stopped them. It goes in with all the little, the intricate legal things we do. Another thing is, again, we can fight it if there's a lack of evidence. If they've charged you with dangerous driving and we go to court a week before, I look at the file because that's when it gets released properly. We look at the file and there's no video evidence and it's just a statement of an officer saying that I thought he was driving dangerously. I'm sorry, officer, but that's not enough as evidence. When he gets cross-examined, he can't prove anything.
What would happen if you got to a final...